My name's Showell. I'm a bankruptcy lawyer in Rock Hill, South Carolina. I've been practicing here for 25 years this year. I practice in North Carolina, South Carolina, appear in most of the bankruptcy courts in South Carolina, and have appeared in Eastern North Carolina and Western North Carolina. This topic tonight is bankruptcy law, and I'm going to start with just giving a brief history of bankruptcy law. I'm not going to go through the materials. I'm not going to read the materials to you. The materials are pretty good. Actually, they're really good. They were written by the bureaucrat who's 3 layers up in the bankruptcy system for this whole region, Clarkson McDowell. He actually lives across the street from me. I've known him for 20 years. But basically, bankruptcy law is not something that hasn't been, that's a new thing. I mean, there's always a publicity about the rise in bankruptcies, and people talk about the tragedy of bankruptcy, and makes you think maybe it's a new thing that's coming up. But generally speaking, bankruptcy's been around forever. There were bankruptcy laws in the 18th century, but in 1898 we had the Bankruptcy Act, and that was the first uniform act passed by Congress that stuck. And that was really what lawyers practiced under until the law changed in 1978, and they created the Bankruptcy Code, which is, I graduated from high school in 1978, so that's all I've ever known. And the Bankruptcy Code has pretty well been the same thing, with some tweaks in '94 that I had to deal with, and a major overhaul in 2005. I'm not going to go over the changes in the 2005 law, because there were a whole lot of them, and a lot of the major changes are outlined in your materials, and they're on my website if anybody wants to look at a lot more detail. The Bankruptcy Code itself is set out in Title 11 of the U.S. Code. Bankruptcy is federal law. You've got South Carolina law, North Carolina law, and then you have federal law, which is the United States law passed by Congress. And Title 11 is where you would find all the bankruptcy code in. That's where you'd find it. The thing about bankruptcy law that makes it a little complicated is you've got the bankruptcy code, which sets out where all the laws pertaining to bankruptcy are, but all the other laws in the world, that literally the world, because international law can impact it, but trust and estate law, real estate law, divorce law, all of those state laws are incorporated into the bankruptcy code. So when you have a case, if you've got somebody who's getting a divorce, they own real estate, somebody's died, maybe left them something, or they die while you're in the bankruptcy, or within 6 months after, you have to know all of those areas of the law to be able to apply the bankruptcy code properly, or at least know how the court's going to apply it. Basically, bankruptcy is just a word, but you wonder, well, what is the goal of bankruptcy? Well, you're either trying to discharge or get rid of debt, and there's some debts you can discharge and some debts you can't. Or you are trying to restructure your debt and maybe re-amortize your loan with a different mortgage. I mean, not mortgage, but a different interest rate. Strip off some of the debt on, say you've got a $10,000 car with a $20,000 lien, you might be able to strip $10,000 of that debt off that car. So there are various goals that you might be trying to attain when you file a bankruptcy. And basically, it's not really like a buffet. I mean, there are a lot of different options, but your lawyer can look at your fact situation and kind of see which situation really applies to you, because which law really applies to you, because there are different chapters, which I'm going to cover next. And which one you can do pretty well is determined by the facts of your situation, not necessarily what you want to do. And the first type of bankruptcy that I'm going to cover is Chapter 7. I do mostly Chapter 7s. I do Chapter 13s and Chapter 11s as well, but I think Chapter 7's the best thing for your credit. You can recover faster. It costs less generally in attorney's fees and costs. And basically the goal is to discharge your debts. You file your case, you go to court a month later, there's a Chapter 7 bankruptcy trustee who's appointed. His job is to look at your budget and make sure that you don't make enough money to have any money left over to do a payment plan with. Because Chapter 13 and Chapter 11 are reorganizations. And the idea is if you could afford to pay your creditor something, then you can't do Chapter 7. And that's a big misconception out there in the general public. People think you can just file bankruptcy, get rid of all your debts. Well, there are a lot of hurdles you have to be able to jump through to be able to qualify. One of them is your budget has to show you're in the hole. Another is this thing called the means test, which I'm not going to even try to begin to explain in this kind of a setting because it's very complicated. It was one of the changes that was put out there in 2005 when the law changed. They created this thing called the means test, which compares your income in the last 6 months basically to the income of everybody else that in that median range of incomes to see if you're above or below it, and then compares your expenses to what the IRS says you should be spending, deducts that from your income, and it looks like a tax form. And they just stuck it on to the end of the bankruptcy forms we already were using. The other, and also one more thing about Chapter 7, individuals can do Chapter 7s and corporations, businesses, partnerships. It's not just for human beings because, for example, Chapter 13 is a repayment plan. Only individuals can do Chapter 13. And so it's a very clear distinction. And to back up, if you do a Chapter 7, you file your case, you go to court, the bankruptcy trustee looks at your budget and the means test to see if you qualify for Chapter 7. And then his second job, if you do qualify, is to see if you have anything he can sell. That's another misconception. Everybody thinks if you file Chapter 7, you're going to lose everything. Most Chapter 7 cases are what we call no asset cases. You don't lose anything because all your stuff is exempt or protected. And I'll go over exemptions in more detail later, but basically your average Chapter 7 case, the trustee says you qualify, trustee says you have a no asset case, and then he's through. Literally, they do 8 every half an hour here in South Carolina. And then 2 months later is a deadline for the creditors to object. And they can object to say that you should not be able to wipe out a particular debt to them. And they have to have a legitimate reason. They have to be able to show that you've defrauded them, which is very rare. And that's fraud, you defrauded them in that you gave them false information in order for you to be able to obtain the loan. You know, you lie about your income to get a mortgage or something like that. The biggest problem would be where creditors might object would be if you have borrowed money prior to filing bankruptcy. The magic number in my book is 4.5 months. And I just came up with that because I've never had a creditor object to somebody's discharge for debts that were older than 4.5 months. So I just make sure that none of my clients have used their credit for at least 4.5 months before they file. And most of them haven't. Most of them haven't used any for years. It's been dried up and they've just been struggling trying to do what they can for that time frame. Chapter 11, well, Chapter 13 and Chapter 11 are both repayment plans. They are where you basically, well, I left out one thing about the Chapter 7, the end result that you want. At the end of the time frame, the 2 months after your hearing, if no one objects, you get a court order discharging all your debts. And there's the code says that your debts are discharged, which means you don't have to pay them. Creditors can't collect from you, and basically it helps clean up your credit. there are debts that you can't get rid of, like taxes that are less than 3 years old, school loans, alimony, child support, and there's a laundry list in the bankruptcy code under Section 523. And the goal in Chapter 7 is to get that order of discharge. Most of the cases that most lawyers file, you end up with that discharge.